A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. I'm glad you've joined us on the program today. Yes, indeed, we are talking about the Kyle Rittenhouse trial. It has gone to the jury. So, kind of in this weird spot where, you know, I can't really offer any predictions about what's going to happen because by the time you see this, who knows? The jury might have come in with a verdict. But there are some issues that we need to discuss. I wrote about a couple of them at Bearing Arms yesterday, but there was just a plethora of things that I would have objected to had I been Kyle Rittenhouse's defense attorney. And a plethora of things that gun owners have been objecting to really, over the course of this trial. Which fundamentally should be about whether or not Kyle Rittenhouse acted in self-defense or not. Fundamentally, right? I mean, that's what we should be discussing here. But over the course of the past couple of weeks, it's become clear that there is an attempt to go after self-defense itself. Dana Lash mentioned this on Tucker on Monday night. But not only did the prosecution put self-defense on trial, they misled the jury about the law of self-defense in the state of Wisconsin. And frankly, they laid out a theory of self-defense that requires you to be beaten before you can respond. I mean, I'm not making that up. This was from James Krause during the rebuttal argument on Monday evening. The last thing the jury heard before the judge instructed them on what they had to do when they're reaching this decision. Everybody takes a beating now and then, arguing that Kyle Rittenhouse should not have fired at Joseph Rosenbaum as Rosenbaum was lunging at him, but that he should have let Rosenbaum tackle him to the ground and maybe beat the crap out of him. In the hopes, I guess, or in the assumption that that's all Rosenbaum wanted to do, was give him a beating. And, you know, everybody takes a beating now and then. Yeah. Prosecution argued that, in essence, when you bring a gun, when you are carrying a firearm around for self-defense, not because you hope to use it, not because you even expect to use it, but because you are concerned that you may have to use a firearm to protect yourself. Prosecution says, in essence, when you do that, I mean, you kind of give up your right of self-defense. Another comment from James Krause, he was too cowardly to use his fists. Yep. Again, I mean, right, hand in hand with everybody takes a beating. You know, nothing really serious going on here. Rittenhouse didn't have to shoot Joseph Rosenbaum. He could have just let Rosenbaum tackle him. He could have had fisticuffs on the ground. You don't bring a gun to a fist fight. That's what the prosecution said. Yeah. But that's not ultimately what the jury is going to have to consider here. Whether or not Kyle Rittenhouse should have used his fists or his feet or even maybe the butt of his rifle to bash Joseph Rosenbaum in the face, which, according to the prosecutor, that would have been fine. That would have been fine. So the prosecution actually sort of acknowledges, yeah, Kyle Rittenhouse could have perceived a threat, a legitimate threat. But it wasn't a threat that Kyle Rittenhouse should have responded with lethal force. Again, based on what we heard from the state's own witnesses, guys like Richard McGinnis of the Daily Caller, who testified that in the nanosecond before Joseph Rosenbaum was shot, that he reached for Rittenhouse's gun, yelled, "Bleep you," and that is when Rittenhouse pulled the trigger. Should the standard really be, well, no, you've got to let yourself get tackled. You've got to let yourself get pummeled before you can act in self-defense. No, that's not what the standard should be. That's not what the standard is. That's not what the standard is in any of the 50 states around the country, much less Wisconsin. As long as Kyle Rittenhouse had a reasonable fear that his life was in danger or that he was about to suffer great bodily harm, then he was legally entitled to use lethal force in self-defense. And the prosecution's case has changed over the course of the past 2 weeks. You know, and this was something that Mark Richards brought up in his closing arguments. That the prosecution never talked about provocation in their opening statement. Their opening statement was that Kyle Rittenhouse, they would show video, Kyle Rittenhouse chasing down Joseph Rosenbaum. Well, they didn't show that. And so now I guess the prosecution's theory is, well, look, even if Rosenbaum was lying in wait for Kyle Rittenhouse, even if Kyle Rittenhouse did not provoke this attack, Kyle Rittenhouse did not have the right to act in self-defense, lethal self-defense, because he could have just punched Joseph Rosenbaum. He didn't have to shoot him. Again, I don't know what the jury is going to do here, but that's not how the law of self-defense works in the state of Wisconsin. Then we had one of the other issues that popped up yesterday. I did not have a chance to write exclusively about this, but I do want to mention this. Thomas Binger, the prosecution, holding the AR-15 used by Kyle Rittenhouse that night. Finger on the trigger. Yeah, a lot of gun owners viscerally reacted to this. Beckett Adams, this picture is giving me gun safety hives. Now, look, in the courtroom, the firearm was checked immediately before Thomas Binger grabbed the gun. Was it unconventional, shall we say? Yes. Very unconventional. Was it, and I was listening to Fox News this morning, Governor Scott Walker said he thinks it might have actually backfired on the jury. He doesn't think that went over well. Was it unsafe gun handling? I mean, yes, technically, because you're not supposed to point a firearm, even one that you know is unloaded, at anything that you're not willing to destroy. But then again, we saw a lot of unconventional, and I would argue destructive behavior on the part of the prosecution throughout this entire trial. So I wasn't shocked to see Thomas Binger do this. And I wasn't shocked to see the left try to make hay out of the right's reaction either. This is Joy Ann Reid from MSNBC. According to right-wing Twitter, it's outrageous for a prosecutor to point an unloaded AR-15 towards the jury to demonstrate how scary that firearm is, but totally cool for a teenager to point a loaded one at people and shoot them. And also, liberals are dumb to fear AR-15s. A lot to unpack there, isn't there? So let's start with the fact that you may not think it's outrageous for a prosecutor to point an AR-15 towards a jury to try to get them to feel fear. You may not think that that's outrageous at all, but I would argue, how many times have you seen a prosecutor point a murder weapon at the jury during a murder trial? I mean, I can't remember that being done. And Thomas Binger's closing argument, as I said at Bearing Arms, the closing arguments between Thomas Binger and Mark Richards, a study in contrast. I mean, Binger was hyper emotional in his argument. Mark Richards was very gruff, laying out the facts, and really not trying to. In fact, I think Mark Richards could have done a better job of trying to get the jury to empathize. I think his closing argument could have been a little bit more emotional than it was. But again, pointing the gun that Kyle Rittenhouse used that night at the jury doesn't change any of the facts about this case, nor does it change, I believe, the burden of proof in this case, which lies with the prosecution to prove beyond a reasonable doubt that Kyle Rittenhouse was not acting in self-defense that night. And again, my personal belief is that the prosecution didn't do that. But again, I'm not on the jury. Then we had progressive Pastor John Pavlovitz, also focused on the AR-15, saying, wearing an AR-15 on your shoulder and claiming you were there to give first aid is like carrying a gas can and saying you'd come to put out a fire. Decent people can admit this. If you can't, that's a you problem. This guy's a pastor? This guy's supposed to like counsel others? People are supposed to want to open themselves up to this guy? Good Lord. Yeah. So, as folks noted, Gage Grosskreutz was also armed that night, was also there as a ACLU observer and as a medic, right? But he had a gun. So is that different because it was a handgun and not an AR-15? Is it different because Gage Grosskreutz was carrying on an expired license as opposed to Kyle Rittenhouse, who was legally carrying his firearm? Do any of those things matter to the left? I don't think they do. Because it's not about Gage Grosskreutz, even though his behavior mirrored that of Kyle Rittenhouse in terms of carrying a firearm that night. Different kind of gun. Does it matter? I mean, I'm old enough to remember when the left wanted to ban not just AR-15s, but handguns too. Last time I checked, they're not really on board with the idea of gun ownership in general. So I don't know from a pragmatic perspective what the difference would be. Somebody like Kyle Rittenhouse, who was carrying a rifle, was also carrying a first aid kit. You can see it strapped to his shoulder too, right? Rifle slung across one shoulder. The first aid kit slung across the other shoulder. The strap sort of, crossing in front and back. Yeah, none of that matters. Not to the left. Again, I wonder, honestly, how much any of the testimony has meant to many of the folks on the left. And I'm sure the same can be said for some on the right as well, too. You go into these trials with the court of public opinion already largely decided. And, as much as I might like to say, well, I've kept an open mind throughout this process, I'm sure that I brought my own bias to watching this trial and the coverage of this trial. I did going in believe that Kyle Rittenhouse had acted in self-defense, but I was prepared to listen to the weight of the evidence. I was prepared to accept that I was wrong if that's what the evidence showed. But I never got there. Just as there are a lot of folks on the left who may have claimed to be open-minded. Well, I think that Kyle Rittenhouse is guilty, but I'm willing to hear what the evidence shows, who continue to insist that Rittenhouse is guilty. What's been interesting, though, is I have run across some folks, and I don't know if they're honest or not. I mean, you never know who's lying or who's being honest when they're saying stuff on the internet, but I have run across a couple of people. I've not been on Twitter as much. I've actually been on the site Reddit in the Wisconsin subreddit. I've been reading, as I've been watching the trial, I've been reading through the comments on the live thread because they have tried to limit the commentary to Wisconsin residents, which I thought was kind of interesting. And so I wanted to see the perspective. And there I have actually run across a number of people who've said, look, I'm on the left. I'm a progressive. I either thought Kyle Rittenhouse was guilty and I've changed my mind over the course of this trial, or I've seen a couple of these too. I think that Kyle Rittenhouse was not a hero. I think he did the wrong thing in going to Kenosha, but I also think the prosecution has not proved their case. I've seen a couple of those folks. I have yet to run across somebody who has said, you know what? Going into this, I thought that Kyle Rittenhouse was innocent. I thought he was acting in self-defense. I've been persuaded by the prosecution otherwise. I'm not saying those folks aren't out there. I'm saying I haven't run into them. And now, of course, we get to deal with the aftermath of this trial. The protesters are already outside the courtroom. National Guard is on standby. And why is that? Who are we concerned is going to riot? Who are we concerned is going to protest in such a violent way that the National Guard needs to be on hand? What side is going to be so angry and disappointed that there is fear that they're going to take to the streets? I mean, maybe the left would say it's both, but I have a feeling they would argue that it's probably the right. I don't think that's going to happen. I don't think you're going to see riots on the streets of Kenosha if Kyle Rittenhouse is convicted. I think there'll be a lot of anger. I think there'll be a lot of frustration. I think there'll be an appeal. But I don't think you're going to see a riot. And I would encourage folks. I don't think you're going to see one, but I don't want to see one. That's not how we do things. Apparently, though, according to Thomas Binger, how we do things, well, if there is a riot, you're just supposed to stay away, right? Even if businesses are burning down, just stay away. And God forbid you respond with a firearm in hand for self-defense. Because again, according to Binger, you've basically lost your right of self-defense at that point, right? And according to Thomas Binger, if you do respond to a riot, if you do go down where a riot is taking place, where there is looting, where there is burning, where there's arson, well, don't step foot on the street. I mean, you might have a right to be there, but if the mob is telling you, stay on your property, you better listen to the mob, right? I mean, that's Binger's whole argument. If Kyle Rittenhouse had just listened to the mob, if he hadn't provoked people with his mere presence, well, none of this would have happened. I got to tell you, I don't think that argument, I don't think that argument actually is going to end up having a lot of bearing on the jury's decision, because Kyle Rittenhouse did have a legal right to be there. He was not illegally possessing a firearm. You know, the curfew charge was dismissed. The gun possession charge was dismissed. So the whole argument that Thomas Binger made throughout the trial, that Kyle Rittenhouse is this outsider, doesn't belong here, came in the nights of the riots because he just wanted to cause trouble. I don't think they presented any evidence backing that up. So I don't think that argument is going to hold much sway with the jury. But in the court of public opinion, I think the left absolutely embraces that idea. And I was thinking about this as I was driving down to the studio today, because, you know, I do my show from Farmville, Virginia, most of the time. I don't live in Farmville. In fact, I live about as far away from Farmville as Kyle Rittenhouse lives from Kenosha. Rittenhouse lives across the border in Antioch, Illinois, about 17 miles or so away from Kenosha. That's generally speaking about as far away as I live from Farmville. And I was thinking about this as I was driving down. I've got friends who own businesses here. I don't live in Farmville. I'm not a Farmville resident. I wouldn't consider myself an outsider. Thomas Binger might. James Krause might consider me an outsider, particularly if I were on trial for murder and they were prosecuting me, wanted to put me away for the rest of my life. Then I'm sure they would portray me as an outsider. But I don't feel like an outsider in Farmville, Virginia, and I don't believe that Kyle Rittenhouse felt like an outsider in Kenosha. But you take away all of those distractions. Kyle Rittenhouse was an outsider. Kyle Rittenhouse should have been there. Well, he had a right to be there. And now you're left with the question of, did he have a right to defend himself? Or was he provoked? Again, I know what my beliefs are based on what the witnesses had to say, based on the video and photographic evidence. But it's not my call. And I just hope and pray that the jury does not let the fear of the mob cloud their judgment. And we actually do see justice done here. All right, let's turn our attention to today's Armed Citizen story, our good deed of the day, as well as our recidivist report. We will start there. Tyler, Texas, where a man has received 8 years probation for shooting towards people at an apartment complex. From the Tyler paper, Jonathan Calvin Mitchell, 46 years of age, pleaded guilty on Monday, sentenced to 3 counts of aggravated assault with a deadly weapon for a shooting incident at an apartment complex back in June of this year. According to police, they were called out to the apartment complex about 7 p.m. on June 11th after Mitchell shot at people at an apartment complex in Tyler. No one was struck. After pleading guilty on Monday, Mitchell received 8 years of deferred adjudication on each charge. And the sentences will be served at the same time, so 8 years probation total. And the probation also gives the person the opportunity to have the conviction removed from the criminal record. Mitchell received 158 days credit for jail a time that he spent in a cell awaiting trial. That's a pretty sweetheart deal, especially considering the circumstances of this case. See, multiple people said that Mitchell was drunk or high, intoxicated in some form or fashion when he was shooting at people. Police arrived. They also believed that he was intoxicated. When he was jailed, he was facing charges of public intoxication, resisting arrest, evading arrest. He wasn't indicted on any of those charges. According to Smith County records, he was arrested twice in 2019 on charges related to driving while intoxicated. Well, I tell you what, Mr. Mitchell would appear to have a bit of a problem. And the criminal justice system would appear not to be too interested in doing anything about it. So I hope and I pray that Mr. Mitchell finds the strength within himself to try to turn his life around, because he's going to have to do it on the streets. He's going to have to do it with all those temptations available to him. But if he doesn't, then I suppose the potential exists for him to actually do some prison time. I kind of doubt that's going to happen, even if he violates probation. I know how the criminal justice system works. So, yeah, a lucky day for Jonathan Calvin Mitchell down there in Tyler, Texas. Today's armed citizen story from, I believe this is Sedalia, Kansas, where a burglary suspect shot by a homeowner. This was just before dawn last Wednesday. Commander David Woolery with the Sedalia Police Department said the male homeowner said he was woken up by his wife, who said she thought that there was somebody in the house. So, male homeowner grabbed his firearm, went to try to find out what was going on, encountered somebody inside the home, 52-year-old Daniel Schnack of Sedalia, to enter the home. Robert Oliver lives next door. He said he watches the neighbor's property when they're away. He said, I saw flashing lights through the window this morning when I got up, and it was dark. He said, at first I thought it was an ambulance, but then I realized it was police cars. Moments earlier, the homeowner had apparently begun going through each room of the house. He confronted Schnack and demanded that he leave the home at gunpoint. Local authorities say he ordered the suspect to leave. The suspect advanced on him. Homeowner backed up for a ways, continuing to order the suspect to leave, which the suspect did not, and the homeowner fired one round, striking the suspect. When officers arrived, they found the family safe. Suspect had fled at the back of the home and away from the scene. They actually soon found him at a local hospital, getting treatment for a non-life-threatening gunshot wound. The Sedalia Democrat asked the homeowner's neighbor what he would have done if he'd been in the same situation. And he said, quote, same thing. He's got a wife and a child in there, 2-year-old, maybe 18 months, I think. He said, you wake up in the middle of the night with somebody standing in your house coming towards you. What do? Well, according to Thomas Binger, you run out of your house. I guess you leave your wife behind. Sorry, kid. I guess that's what you do. Maybe you take a beating. Maybe you see Mr. Schnack just wants to, pummel you a little bit. But God, once you pick up that gun to check out and see if there's an intruder in your house, according to the prosecutors, now you're the aggressor. Yeah. Even in your home, apparently. Well, police in Sedalia see it differently. They say that they're not filing charges against the homeowner for anything at this time. Quote, he did what he felt was right and what he needed to do to protect his family. With the Castle Doctrine, he was within his rights to do so. Today's hero of the day from Philadelphia, Pennsylvania. This is, take a look at this picture real quick. For those of you who are listening on our podcast platforms, I'll describe it to you. It's a car underwater. This was in Philadelphia, actually. Sometimes when we have our cars go into ditches stories, a lot of times they're Florida because a lot of those canals. No, not this one. This was in Kennett Square, Pennsylvania, just outside of Philadelphia, I guess. Vehicle plunged into a creek, a woman inside. She had to climb into the back seat because the water was coming in. She ultimately had like a 6-inch air pocket. But Officer Mark Todd was driving by and he actually saw what was going on. And he said, I dropped my duty gear. I went into the water. I did pretty much what I assume any other officer would do. I broke out the back window. He had basically that, the little tool that you can use to break the glass. That's what he did. He said it was a race against time. Water's filling up the car. Woman screaming for help. He said, I opened the door, the vehicle sinking as I was getting her out. During the rescue, Todd says the water was up to his chest. He said he could no longer stand. A water temperature, obviously, very cold at that point. He said, but my adrenaline was going. Said I didn't even feel the temperature, to be honest. But he's okay. Woman is okay. car itself, well, the car was pulled from the water, but I would call it a total loss. But you know what? Stuff can be replaced. People can't. In the right place at the right time, willing and able to do the right thing. We give a big tip of the hat to Officer Todd there for jumping in those freezing waters and saving a woman's life. That's going to do it for this edition of Bearing Arms Cam & Company. I want to thank you for being a part of the program as always. Don't forget, if you like what you hear, you like what you read at bearingarms.com, you can become a VIP subscriber. Just use the promo code GUNRIGHTS and you'll get a significant discount. You'll also get exclusive analysis, commentary, news stories you won't find anywhere else. If you upgrade to a VIP Gold membership, you're going to get all of that from every website in the Town Hall Media family. That would include Hot Air, Twitchy, PJ Media, townhall.com, obviously, Red State. And you'll also get exclusive access to a VIP Gold live chats. We're going to be doing one with Hot Air's Ed Morrissey on Wednesday afternoon. So again, check out bearingarms.com/subscribe for more details. Thank you so much for your support. Until we talk again, be well, be safe, and be free.